Yeah, exactly. Like the capital person E, I just go like D. Or like an F. Yeah, I know. Sometimes
Hello? All right.
I'm not kidding. Do you remember when Ricky Fidel did his is that a mystery? Yeah. I remember this. He was like this. And then he saw Captain, like, I'm just in uniform. He's like going off paths. That's so gay. That's so
All right, welcome back. Miss me? No, just kidding. It's always tricky when you have the holiday, the second week of class, and then a snowstorm. So anyway, we're here. We're back. If you did not watch the lecture and you did not sign in, please email me. I'll give you credit. But you have to watch by the end of this week. Okay? All right, good. So let's recap. I know none of you remember what we were doing last week, so we'll just sort of rehash. Constitutional law. We started our semester with Marbury versus Madison, probably the most famous case of all time. But it shouldn't be that famous. Marbury simply just restated a principle that had been in existence for many years. Hamilton is described in Federal 78. This concept of judicial review was not invented by John Marshall. It existed from time immemorial. The idea is this. When you have a higher law that conflicts with a lower law, the higher law prevails. And the courts have long asserted the power to decide the meaning of the higher law. That is, the legislature, that the people who write the law can't always decide the meaning of this law. So what happened in Marbury? You had a conflict. The statute says that the Supreme Court can issue what's called mandamus, an order in the original jurisdiction. Chief Justice Marshall said, no, you can't do this because the Constitution fixes, it sets in stone the Supreme Court's original jurisdiction. It cannot be expanded. So when there's a conflict between the statute and the Constitution, which prevails? The Constitution. Now we study that Marshall made the best reading of the statute. And in fact, Marshall maybe was responsible for the entire case because he was the one who didn't deliver the darn commission. But all that aside, Marbury became this precedent. Now the Supreme Court didn't just go say, we're going to now declare all these laws unconstitutional. In fact, in the basically, 150 years after Marbury, the Supreme Court said almost every federal law was valid. A few exceptions here and there, but for the most part, Marbury didn't have that much of a big deal. So everyone knows Marbury. Can I tell you what's probably the most important case ever was? In my opinion, at least. McCulloch to Maryland. Not the most important, top 5. This is the case that established the supremacy of the central government. Without McCulloch to Maryland, we would not have a country. If any one state could punish or regulate the federal government, our nation wouldn't last more than a few minutes. And McCulloch is important for another reason. McCulloch established this principle of the necessary and proper clause. The concept that Congress has powers that may not be expressly defined in the Constitution, but implied in the Constitution. All right, by the way, please sign into the attendance. About 15 have not signed in yet. So let's talk about what express versus implies mean. You're not really soon. Conrad, I guess you're first. What's the difference, Conrad, between express and implied or implicit?
So something that's expressed is going to be said or written or like visible. Something that's implied, you would need to. It wouldn't make sense without it.
Okay, that last thing you said, I'm not sure I followed. It wouldn't make sense without it. Just expound on that a little bit more if you can, please.
If something's implied, you need to assume that that's there for what's actually going on to make sense.
Give me an example, maybe?
in the doghouse, and it's like, there's an implication that I'm not.
So I didn't say misbehave, but that I'm implying to do something bad. Okay, Bobby, let me ask you a related question. Where are the powers of Congress listed in the Constitution? Let's see if you remember that from last week. Where in the Constitution are the powers of Congress listed?
In the actual articles themselves.
Which article? Which article is Congress's powers? No, one at a time. You'll come later, I promise. Bobby's on call now.
I believe it's 1.
Okay, Article 1. More specific? There's sections in Article 1. This is important. Article 1, section what? No. Yeah. Jim?
No, Blake.
Was you?
Blake.
Give your name tag?
I didn't get a name.
All right, come get one for me after class. But you were in the first day. Which section of Article 1 are the Congress's powers listed in?
Isn't it multiple sections?
In particular, there's one biggie. Man, what's your name? No name tag?
Yeah, I switched my
Do you know the number?
8.
Section 8. That's right. All right, so everyone go to page 34 of your pocket constitutions, which you should all have. Thank you very much. We will spend, I would say, the next, month, not exaggerating much, on Article 1, Section 8. It's true. So you're right. There are powers of Congress listed elsewhere in the Constitution. Kind of, maybe. It's actually a debate if they are, but I'll agree just in theory at least. But almost every power that Congress has is listed. Now, who doesn't have their pocket constitution? For shame. For shame. Did you get one?
I did.
Someone left theirs behind. I picked it up just in case. A couple of you left it behind the class notes. It just makes me very sad. One year for Halloween, I gave these out for trick-or-treaters. I'm serious. The parents were so happy and the kids were so angry. It was just, it was poetic. This will not rot your mind. It will not rot your teeth either. So let's just go through these. This is where Congress's powers are listed or enumerated. Brenda, what does enumerated mean? What does this word? We see this word a lot, enumerated. What does enumerate mean? Yes, listed. What do you mean listed? You're correct. Use my word. Good. What does it mean to list something?
They specifically stated
Correct. What's the opposite, Brenda, of enumerated?
implied.
Good. Okay. Express. Enumerated. It's the same thing. And as Conrad told us a few moments ago, the opposite of express or enumerated is implied. Or, if you will, unenumerated. Have you heard that word? Enumerated, unenumerated. Look at the Ninth Amendment, right? There are rights that are not enumerated, unenumerated. Okay? All right, so let's go through these one at a time. So I'll just read them to you and just follow along with me. Okay. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, pay debts, provide for the common defense, and so on. Okay. This first part is about taxes. This is important. The Articles of Confederation, could they impose taxes? No, they could not. All they do was ask or request or requisition funds from the states. Next, Congress can borrow money. Also very important, right? When we had a new nation, we were broke. We didn't have any money. We had to borrow money to establish credit. The next one's a biggie. We're going to spend a lot of time in this one. Congress has the power to regulate commerce with foreign nations among the several states and with the Indian tribes. All right. And just reference, I have this one on the board. We'll keep this one up there just for the rest of the class, okay? Next, Congress can establish rules of naturalization. That means immigration. And bankruptcy law. This is actually a big deal. State bankruptcy laws would mean that people don't have to pay their debts. The states would say, you don't have to pay your debts, congratulations. The federal government says, no, we're not going to do that. We're going to have Congress set the rules about bankruptcy. Who gets to coin money? The feds. It was a huge problem that every state had their own currency, which leads to inflation. Very bad. Congress can punish counterfeiting of those coins. They can establish post offices. Again, a single method of communication. Next page, go to page 36. They can establish what are called copyrights and patents, the sciences, and useful arts. Congress can create inferior tribunals. That means lower courts. That's why we have courts below the Supreme Court. The power is right there. Congress can punish piracies. Congress declares war, not the president. Very significant power. Congress also raises the armies. The president's the commander-in-chief, but Congress gets to raise the army and fund them for no more than 1 year. Why is that there? So you can't have a war going forever. Congress will come back each year to fund it. Congress maintains the Navy. They can regulate the Navy. Congress make the rules for calling forth the militia, and they can arm them. Okay? Go to the bottom, page 37. I'll jump ahead a little bit. And this one's important. Congress shall have the power to make all laws which be necessary and proper. Necessary and proper. For carrying to execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or any department thereof. So I want to just focus on this phrase. The Congress shall have power to make all laws which be necessary and proper for carrying to execution the foregoing powers. Let's let's break this down for a few moments. William, let me ask you a question. So this is Clause 18, Article 1, Section 8. And the Commerce Clause is Clause number 3, right? When it says here foregoing powers, foregoing, what does that mean, foregoing powers?
I believe that's everything going after Clause 18, or is it everything before?
Which one is it?
It is the before.
Michael's nodding his head. Before or after, Michael?
Before.
Yes, sir. Bills fan?
Yeah.
I'm sorry.
I know.
Yeah, it's okay. That's close. That's close.
It
That's close. That's close. Fourth down. That's close. Anyway, so foregoing. Are you from New York?
No, I'm not. I just really like how Josh Allen plays.
All right, that's cool. All right. So foregoing, as tag team corrected, means coming before. So what this means is we have these provisions listed, number 1 through 17, right? Commerce, borrowing money, laying taxes, and so on. These are all the powers that are enumerated or express. And then we get to number 18, which says Congress has another power. It's an implied power. It's not expressly stated, but it's an implied power. And what's this implied power? To carry into execution the foregoing powers. Wait a minute, what does it mean, the foregoing powers? In other words, if you want to do something in 1 through 17, you got some wiggle room. I'll just give you a very easy example. Post offices, right? It says right here, they can provide for postal roads and post offices. Okay. Does it say they can buy horses for those postal roads? No. Does it say that you can buy wagons for those postal roads? No. Does it say that you can hire letter carriers, which is called mailmen, I guess, right? No, it doesn't say that. All it says is you can establish post offices and post roads. Does it say who can work there? Who can carry the mail? It just says post offices and post roads. Michael, I'll ask you a question. Michael, would you say that in order to have a postal system in the 1800s, it was necessary to have horses?
Yes.
I would say so. What about wagons?
Yes.
People to carry the letters, think that that's pretty important?
I do.
So, Michael, the follow-up question is, do you think it's necessary and proper to have a law buying wagons and horses to execute the postal power?
You have a law doing what?
That purchases wagons and horses to execute the postal power.
I do.
Now, that's not expressly stated in the Constitution, is it?
Mm-hmm.
It is.
It's
the opposite of express is.
It's impliedly stated, implicitly stated.
Ooh, even better. Implicit, yes. Implicit, implied, same word. Very good. By the way, do not confuse imply and infer. People do this all the time, Judge Matt, right? I'm implying something. I'm saying, take a hint, right? Here's the implication. You infer what I'm saying, right? I am implying something to you. You infer what I'm implying. Don't confuse it. People confuse all the time. It drives me batty. So yes, The necessary and proper clause, sometimes called the elastic clause, it stretches the Constitution just a bit to give the government some wiggle room. It's also called the sweeping clause, that it sweeps in all these other powers that are not stated. There are a lot of names, necessary and proper, sweeping, elastic, it's called a lot of things. This is probably, after the supremacy clause, the most important part of the Constitution. Maybe top 5, I have to just rank them. Because it lets the government do stuff that's not expressly stated. And think about it. In McCulloch, Marshall says, we can't forget this is the Constitution we're expounding, intended to endure for the ages. What's Marshall talking about there? He's not talking about the courts get to make up whatever they want. That's for sure he's not talking. That line's interpreted wrong all the time. Marshall's not saying we can just interpret the Constitution based on whatever we think today. No, what he's saying is it's for Congress. That Congress is intended to endure for the ages, and they have to have some flexibility, some wiggle room to accomplish the issues of the day. Right? It's not about the courts having power for the ages to interpret the Constitution as a law change. It's for the elected branches of the legislature to do it. This is, by the way, people miss this all the time. So yeah, this camera's running. People at other schools watch this. I got an email last week from a student. I sent to Adi, it's true. Another law school, won't say where it is. He said, my professor said that John Marshall made up judicial review, and he didn't mention the Federalist Papers. I'm like, oh, really? So I said, go show him Federalist 70 and see what happens. I'm sure he'll report back after class today. So you're welcome. But the point is, this is all very tied together. All right. So we have this Constitution. And almost immediately after the Constitution is ratified, we have a major test for what the relationship is between the Commerce Clause and the Necessary and Proper Clause. And this involved the Bank of the United States. The Bank of the United States. Now, has anyone seen the Hamilton musical? Please, more hands. Is anyone going to go see it at the Hobby Center? Oh, please. You should go. So, anyone have Disney Plus?
I do.
Good. We'll start there. So, I want to play a clip. By the way, I'm going to mute the YouTube. I'm sorry, YouTube. The reason why is I get a copyright claim whenever I play this clip, and I get. It's actually really funny. They take down my lectures because I'm playing Disney. Sorry, YouTube. Mute back my 5 minutes. So, the setup of this is the Hamilton musical. And there's a debate between Thomas Jefferson, James Madison, and Alexander Hamilton about whether the Bank of the United States is constitutional. All right. I put the captions on. If you can't see it, I put the lyrics in the syllabus. Follow along. But just lyric. Sorry, YouTube mute. It's going to the Hobby Center next month. I can't watch. I saw the original. It was close to perfect Broadway as you can get. Anyway, this 4-second clip describes the bank controversy. How you do? Welcome back. It describes the bank controversy almost perfectly. The northern states favored the bank. Why? They were importing stuff. They were engaged in commercial transaction. The southern states, the primary economy was agriculture, backed by slavery. They opposed the bank. They wanted things they could plant in the seeds, as Jefferson said, plant something that they could actually see. But beyond the sort of the policy debate, there was a constitutional debate. Did Congress have the power to charter a bank? And we look at this text, right? We have these phrases, necessary and proper. Necessary and proper. Congress can't do whatever they want to carry into execution the foregoing laws. They can only take steps to carry into execution laws that are necessary and proper. Jake, help me out here. What does necessary mean?
Essential.
Essential? Oh, man. Is it something you can do without?
No,
So something you absolutely need.
it's necessary.
What if it's something that just might be useful for you? Is that necessary? You know, do you need a brand new car? It'd be nice if you have one, right? Be good to get around in, but you need one?
You don't need one, you just need a car.
Nick, what does necessary mean? Does necessary mean it's absolutely necessary? Or does it just mean that it's necessary?
Well, I think it means like required, but that's not really how they
Required. Okay. Ted, let me ask you a question. What does proper mean? Proper. Those two words are necessary and proper. It's got to be both of them, right? What does proper mean?
Within the spirit of the law.
Oh, that's interesting to see. A Montesquieu guy. What's the spirit of the law? He's laughing.
In the same sense and idea of the people that wrote the Constitution.
Who gets to decide what proper means, Ted?
Well, whoever that is, people.
So Congress. The courts? The courts could decide what proper means? How do you know? Well, this is just 1789. We don't have an opinion yet. I'm telling you, we are in the first Congress. James Madison's a member of the first Congress. Thomas Jefferson's a Secretary of State. Alexander Hamilton, the Secretary of the Treasury. George Washington, the President of the United States. I mean, you don't get more framer than that, right? These are the people who created the country debating an issue of constitutional law. You know what? They didn't agree. Again, just imagine whatever our cabinets look like today, right? You have, again, Thomas Jefferson, Alexander Hamilton in the cabinet, George Washington in the presidency. There was no White House back then. And you have James Madison in this Congress. And they're debating it. They didn't actually rap about it, but you can imagine they might have, right? Right, so is that Chanel? Chanel, let me ask you a question. How did Hamilton and Jefferson understand the terms necessary and proper?
I think Jefferson said that necessary was, he said it was absolutely necessary.
Correct.
And Hamilton said it was useful, not just
Oh, you're correct. Very good. So we have this debate. Hamilton was the one backing the bill. In fact, it was his idea, right? You see it from the video, right? Hamilton said, look, This is meant to allow the government to have some flexibility. Hamilton said that necessary means useful, maybe even convenient, right? If this is some useful way for Congress to execute their foregoing powers, then it's good enough. And Hamilton also thought it was for the legislature to decide what is necessary. He wasn't thinking about the courts, my goodness. But the other side, you had Thomas Jefferson and James Madison. Again, these were important people. And what they said was, no. Necessary means essential. I think that's what Jake said a minute ago, right? Almost strictly necessary, or Nick, required. I think you said required, right? These are all good words. And what's fascinating here is the ink in the Constitution was barely dry, and there's already disagreements on what language means. That's not bad, right? That's actually a good thing. When you have a written Constitution, it makes people to decide, what do these words mean? This may not seem like a big deal to you, but it is. In another country, they'd say, well, George Washington's president, he can do whatever the hell he wants. But they are having debates with the meaning of language and law. From the beginning, we're focused on text. They may not agree. Look, put 4 lawyers in the room, you get 5 opinions. I get it, right? It's how we work. We've been like this forever. Jefferson legal training, Madison legal training, Hamilton legal training. They're basically lawyers, right? It's no different than you are. Okay? So then where we left off, Hamilton says, Washington, you can do this. All right? Hamilton says, Washington, you can do this. Jefferson and Madison say, no, you can't do it. Who does Washington listen to? Lauren, who does Washington listen to? Yeah. Hamilton was his boy. I'm not saying that literally. There are actually rumors that it was actually his son. It's not true, but this is actually hinted at in the Hamilton musicals. One point, Washington says, he calls him son. It's very deliberate. Washington had no biological children. That's known. In fact, there's some suggestion that he had some disease when that might have actually rendered him sterile. I can't remember, something he picked up in the tropics somewhere. But he was close to Hamilton. Hamilton was basically an adopted son to him. They were so close. And Washington protected Hamilton many, many times. Okay? Everyone with me so far? Or maybe Hamilton didn't persuade Washington. Maybe Washington said, look, if Congress judged this bill to be proper, that Congress passed the statute, that's good enough for me. And that's not crazy either, right? If Congress passes a bill, the president can just say, you know what? All right, that's good enough for me. So then we get the Bank of the United States bill is passed. But this bank became unpopular because it basically gave certain people very powerful economic privileges. I don't have to go through the specifics, but it became unpopular. Some years later, James Madison, who then became president, renewed the Bank of the United States. Was he being a hypocrite? No, I don't think he was. I think what he basically thought was, look, this has been around for, at this point, almost 2 decades. Congress renewed it. You know what? Maybe that's good enough. And look, that's not a crazy position to take. There's a thinking in constitutional law that if there's some long-standing practice which people aren't challenging, that sort of suggests that it's probably valid, right? If there's people doing something for a long time and no one's stopping it, then maybe it's okay. But then the second Bank of the United States was rechartered. At this point, it was very unpopular. And the state of Maryland decides to do something about it. Is that Anna? Anna, what does Maryland do to the Bank of the United States? They do something very particular to it.
They start taxing it.
How? How do they tax the bank?
Well, the bank is chartered in Maryland, so there's usually like property taxes.
Close enough, yeah. Very, very good. Basically, the Bank of the United States had to purchase what's effectively a stamp, right, from Maryland, the state. And if they failed to use the state certificate, the state stamp, the state would impose penalties on the federal employees. So, who am I to? Damon. Who's McCulloch? Yeah, he worked for the bank. And then what happened to him, this poor guy? They went after. What do you mean? What do you mean they went after him? Yeah, but what did they do to poor Mr. McCulloch? What happened? Why is this kid McCulloch in Maryland? What does poor Mr. McCulloch do? Yeah, he failed to pay the fine. Right? McCulloch failed to pay the fine, and he wasn't going to. Right? So the case was actually McCulloch against Maryland. In other words, this poor guy McCulloch wouldn't pay the tax, and then Maryland sued McCulloch to cover the tax. Everyone get that? So this is not like in the modern era, right? How do things work today? Congress passes a law, and someone sues to say this law is unconstitutional, right? That's how things usually work. Or the president signs an executive order to whatever happened in the last 5 minutes, right? Unconstitutional, stop it, right? That's not how this case arose. Instead, the case arose differently. Maryland tried to regulate this federal institution, and the federal employee McCulloch refused to pay this tax. The Maryland Court of Appeals, the highest court in Maryland, upheld the tax. And the case was appealed to the U.S. Supreme Court. So there's sort of two questions here that have to be addressed, right? First, is a tax constitutional, right? Can the state impose a tax on this federal institution, right? That's the first question. But there's actually like an earlier question, a threshold question that must be answered. Right? Rick, what's the more basic question the court has to address here before they can decide the tax is constitutional? Well, you're right at preemption. That's actually the second question, right? Does the federal bank preempt any state tax? But what's the question to ask first before you get to the preemption question? What does the bulk of Chief Justice Marshall's decision focus on in McCulloch?
Whether the bank's charter was legitimate?
Yes. Did Congress have the power to charter the Bank of the United States? The basic, the most simple, not simple, but the most sort of fundamental question in this case. Did Congress have the power to charter the Bank of the United States? Because if Congress, I can't see your name, Paulina? Paulina, if Congress did not have the power to charter the bank, what happens? Do we care about the tax? Yeah. If the Supreme Court ruled the bank was illegitimate, that there's no power, there's no bank. It ceased to exist. If Congress did not have the power to charter the bank, then there is no bank. Correct. Thank you. So before we even get to the preempt, and Rick, you're 100% correct. This preemption issue, that is, does a federal law preempt a state tax? Before we get there, right? Before we get there, we have to ask, is the bank itself constitutional? So, Stephen, how does Chief Justice Marshall, again, if you're noticing a pattern, Marshall wrote Marbury, he wrote McCulloch, he wrote Gibbons, he wrote a Barron, another case for today, Barron v. Baltimore. He wrote almost every important decision from this period. And it's actually, let me just make this point, wait a second, Stephen, make this point briefly. Historically, the Supreme Court used to write opinions called seriatim. You ever see this word? It's a weird word. Seriatim. S-E-R-I-A-T-I-M. Seriatim. What does seriatim mean? Individual, right? One at a time. Can you imagine this? Each member of the court writes their own opinion. There's no majority opinion. Each member writes their own opinion. So if 5 members in the court, you get 5 opinions. And then you have to figure out what the holding is. You think reciting a case is hard now? Imagine trying to read 5 separate opinions. Figure, oh man, what's the common thread here? What's the holding? That's how ConLaw used to work back in the 1790s. So one of John Marshall's innovations was to bring the court together to have a unified majority opinion. John Marshall, again, I think he's overrated in a lot of ways, but he did some very important things. This is one of them. In fact, he was very good at making the judges like each other. It's a skill that's not all chief judges have. He used to have all the justices board, basically at the same hotel room. And he would always have this thing where they would basically just drink together. What else you can do back then? There's nothing to do, there's no TV, right? They would drink together. And even if it was early, Madeira wine, he loved Madeira, type of a wine. He always say, you know what? Somewhere, he always say, it's raining outside. We need to drink some wine to warm us up. And if it was sunny outside, you know what? Somewhere in the United States in our jurisdiction, it's raining, so we can drink now. That's like it's 5 o'clock somewhere, basically. But he was, anyway, he was very good at bringing people together and making them sort of unite, and he was excellent at this. So, Stephen, patiently waiting, just dreading anticipation. How did Chief Justice Marshall go about considering or deciding whether the Bank of the United States was constitutional?
Also, the main, he does a lot because it's pretty long, but like.
But this is not long, by the way. You get longer opinions, so just hang tight there. Okay, but yeah, it's long for now. Long for the second week of class.
Well, like he breaks it down by kind of, he like goes through all the different reasonings, but the main one was that like the power was enumerated, but not the means and methods of enforcing the power. So he just goes through and gives out reasons why it's more of a enlargement rather than a limitation.
All right, let's do a poll question if I can, please. Everyone, just look at question number 1. Stephen sort of set this question up nicely. So the question is this: number 1, which enumerated power or powers, plural, in Article 1, Section 8, did Chief Justice Marshall rely on in McCulloch v. Maryland to uphold the constitutionality of the Bank of the United States? A, Commerce Clause. B, taxing power. C, necessary and proper clause. D, all of the above. Which one? Take another 20 seconds. All right, 5 more seconds. Get your answers in, please. 4, 3, 2, 1. Okay. All right. Ooh, this is a close one. Look at this. Oh boy. Joseph, what'd you put here? Why'd you say all the above?
Well, the necessary and proper clause is like what he actually uses, but he says that incorporating the bank is sort of implied or it's convenient for the other two as well, for commerce and tax.
Huh. Dalen, what'd you put?
I also put D.
Trent, you put D also? I'll come back to you. Who put C? Yeah. Who? Oh, you're kind of next. Yeah, sure, close enough. Why'd you put C?
I thought it just,
Why did you not put D? Let me ask a question like this.
I mean, I don't know. I think that it's, even though it's like discussed, I have it written, so I just lost my.
Steve, you want to try again? Here.
Well, he goes through a humongous thing about tax and how like all the implied powers to do tax. So I mean, that's not C, so it's D.
No, I'm looking for someone who put C. Yes, Chanel?
It's because the bank, I didn't do all of that because the bank is not the one taxing, and they're not the one involved in the commerce.
Oh, you told me Gonzalez, E, Evelyn. I remembered, good. My daughter's a girl in the Evelyn class, I remember it. Okay, good. What'd you put here? Okay. I want another C. Anyone else C? Angelica?
I agree with you.
Oh, that's a nice answer. Yeah, in the back.
So I put C because the question was whether Congress had the power to create the federal bank. So we went through the necessary and proper clause to see if they have the power or not.
All right, let's do this one at a time. So I don't give multiple choice answers on the exam. I hate them. I think C is the better answer here. And let me explain why. I know. This is close. This is almost 50-50. Let me explain why. Let me explain why to you. I think Chanel actually made a fair point the way she said it. Marshall certainly talks about regulation of commerce, right? He talks about taxing. But does the bank do either of those things? The answer is no. Now, let's put it this way. Today, how do we pay taxes, right? You never even see the money. It just comes right off your paycheck, right? You never know it exists. But back then, how would people pay taxes? They'd have to submit them to a federal depository, right? In other words, in order for people to pay taxes to the federal government, having a bank was a useful or convenient way of doing that. And what do you pay taxes with? Federal currency, federal coins. And where do you get these coins from? The bank. So having these bank branches in all the major cities would make it more effective to facilitate the taxing system. And what about commerce, right? What do you use to engage in commerce between the states? Money, coin, not state money, federal money. This question drives people nuts because you want to put all the above, and that's why I put it there clear. You're not wrong, and in fact, I think a lot of, I'll be kind of candid, a lot of law professors might say it's all the above. But almost every single case we do this year involving implied powers is actually a necessary and proper case. Even when the court says they're talking about commerce, they're really talking about necessary and proper. Think of Gibbons, our next case, right? Where Marshall says that you can't regulate the purely internal commerce of a state. He says that. But Congress will. Trust me, they will. They'll say that a farmer grows wheat in his backyard is subject to federal power. Why? It's necessary and proper. It's a means of executing a broader scheme of federal governance. This is why, after the Supremacy Clause, necessary and proper is most powerful. So I'm going to say C is the correct answer. And I think the reason Chanel mentioned, but I know exactly why I put D. In fact, this question, I have a thing in my notes. Students will be mad at me after this question. I know you're probably all mad at me. You're not graded. That's why I don't do multiple choice questions on exam. I think at ConLaw that's probably very unfair. I actually had, can I make a confession? I got a B+ in ConLaw. Do you know why? It was a multiple choice exam. My professor became a very good friend of mine later. I still gave him crap for it years later. But
Here, right?
that was my other professor. He gave me an A-. Good memory. Right. So I got a B+ in ConLaw 1 and A- in ConLaw 2.
Look at you now.
Look at me now, suckers. Yeah, but so I got a C+ in torts. I still don't get negligence to this day. I don't understand it. I just don't. I don't get it. Don't ask me negligence. I have no idea. It doesn't make any sense to me. But here I am. Okay. All right. Where was I? So camera. AI is London, so I'm looking at the ceiling now. Back to me. I'm here. I'm here. There we are. Okay. It has these weird hand gestures. I go like this, and then like it loses me. Okay, now it found me again. It's like this weird Wally robot that follows me around. So I think the better again answer is it's an aspect of necessary and proper. All right, so let's just walk through this, right? Marshall, like Marbury, basically rips off Hamilton. He doesn't cite Hamilton, but he's ripping off Hamilton. We all know it's there. Hamilton said necessary meant needful, requisite, useful, conducive. Hamilton did not say convenient. Marshall did. Marshall added the word convenient, which actually makes it even broader. So in other words, if there's something that makes it convenient for the Congress to accomplish its other powers, yeah, go ahead and do it. He defined necessary very broadly. And Marshall says the bank is a convenient, a useful, an essential instrument for Congress to have fiscal operations. It's just helpful for Congress to have, and that's good enough. Stephen, yes, sir.
You said convenient, useful, and what was the third one?
I'm sorry, convenient, useful, and essential. Convenient, useful, and essential tool to have fiscal government. Okay. And here's this line. Marshall says, we must never forget that it is the Constitution that's intended to endure for the ages. People often cite to say, aha, that means that the Constitution must change over time. No, that's not what it means. What he's saying is we have a Constitution written, but Congress must deal with present-day situations, must give them flexibility. This is not about the courts rewriting the Constitution. People just bastardize this sentence all the time. It's really bad. He says, our Constitution is intended to endure for ages to come and must be adapted to the various crises of human affairs. The adaptation is occurring in the legislature, not in the judiciary. Okay? And then Marshall has this test, right? Let me just paste it here because it's too long for me to read. Okay. This is a very, very famous quote, and just you may not memorize it, but you'll remember it. It says, "Let the end be legitimate." What does that mean? Proper, heady, spirit, right? Just because something's necessary doesn't mean it's proper. It must be accomplishing a legitimate end. Something that's consistent with the spirit or the intent of the Constitution, whatever that means. You don't really know. Let the end be legitimate. Let it be within the scope of the Constitution. All means which are appropriate, which are plainly adapt to that end, which are not prohibited, but consist of the letter and spirit. That's what he said, spirit, right? Of the Constitution are constitutional. This is a very broad understanding of federal power. And look what he's doing. He's saying, look, you have the means and the ends. In other words, you ever hear the expression, the ends justify the means, right? The end is what are you trying to accomplish, and the means is how you're getting there. And he's sort of balancing the means and the ends. The means and the ends. This is called means ends scrutiny. You'll see this, means ends scrutiny, where you say, well, what are you trying to do, and how are you getting there? And let's say, is it really worth it, all this stuff you're doing to get there? The answer is yes, and this is a good law. It's a balancing test. We'll do lots of these sort of balancing tests in common law. Okay? Still, though, he puts a limit on this power. Marshall puts a limit on this power. Okay? He says, I'll just put this quote up here. Implied means implicit, right? That you can kind of reason from one to the next, but you can't go too far. You can't use a necessary and proper clause to create a great substantive independent power. Remember, great substantive independent power, GSIP, that's how I remember it. Right? You know, imagine Congress says, okay, look, we want to regulate commerce. What we're going to do is we're going to basically put every single American, have a person sitting in their home and then reading their checkbook every night. It's implied. It's convenient. It'd be really convenient to have this person looking at your checkbook every night. That's too far. Right? You want people to have health insurance? That's great. You can't make them buy broccoli. Get to that in a couple of weeks, right? That is too far. It's a great substantive independent power. So Marshall, again, he has this bad habit. He uses this very broad language, but then he puts limits on it. He was a smart judge. Please don't get me wrong. He was a smart judge. He knew what he was doing. But he has this very broad language and these limits. The problem is people cite his broad language and they forget about his limits. The court wouldn't actually put any teeth into this phrase until the year 2012. I'm not exaggerating. In the Obamacare decision. It took almost 200 years to actually put some teeth into what that meant, the limitations of necessary and proper power. Okay? Everyone with me? Yes, Addie.
Just a clarifying question.
Addie, I've been saying your name wrong for 2 years.
I know.
Yeah.
Okay.
Yes.
For your multiple choice question about the necessary and proper clause, you weren't implying with that answer choice that it was just the necessary and proper clause linked to nothing else?
Correct. The foregoing powers are the Commerce Clause and the taxing power, but it's a necessary and proper case.
Okay.
Correct. Everyone get what she just said? To be sure, the necessary and proper clause has to be linked to some foregoing power, such as regulation of commerce and the taxing power. That's what foregoing meant. I think it was Conrad's question 30 minutes ago, right? But those are not, but it's not a regulation of commerce. It's not a tax. The bank's not self-taxing. For example, when Congress, we'll do this case in a few weeks, when Congress banned the possession of a gun in a school zone, that's a case called U.S. versus Lopez from 95 or 96. That was not a regulation of commerce. It was a necessary and proper case. But what was the justification for the law? That people having guns in school zones would have an effect on interstate commerce. That was a necessary and proper case. The court itself is actually not precise with this language. You're gonna see it. The judges are sloppy. The law professors on this are actually kind of sloppy. It's welcome to the world. People don't always approach things as carefully. They don't pay attention to text. The text matters profoundly. All right, so 30 minutes ago, Rick mentioned preemption. Rick, what is preemption? You gave me a really good answer, but just wasn't ready for it yet. I'm ready now.
That's whenever there's a federal law and then the state law is in conflict with the federal law.
Correct. Preemption means you have a federal law and a state law. We follow the higher law. What's the higher law of the supreme law? The federal law. So the federal law preempts, or if you will, trumps the state law. The state law has no effect. This is the supremacy clause. So if, who am I up to? I'll come back to Joseph. Did I call on you before? Did you get a question?
Yes, sir.
No, Dalen, you didn't get a question, did you?
I just the multiple choice.
Yeah, Dalen, let me come to you then, sir. So Dalen, let me ask you this question, please. If the federal bank in the United States is constitutional, can the state impose a tax on the federal bank?
No,
Why not?
because I think the case said that if that were to happen, that would mean that the states are destroying the federal government
The power to tax, the power to
destroy. Yeah.
You ever wonder where that came from? You've heard that before, right? Yeah. By the way, there's a line in this opinion that speaks of government of the people. That sound familiar? Government of the people, by the people, for the people. Yeah, I'm pretty sure Lincoln got his Gettysburg Address from John Marshall. Again, I can't prove it, but it's just, I mean, maybe to make it up, but I mean, it's a very, if Lincoln was a lawyer, he would have known this case back. Look, the same way you're reading McCulloch, Abraham Lincoln read McCulloch. Trust me, I promise you, he was a law student. There was no law school, but he studied law. Everyone read this case. Lincoln argued before the Supreme Court. It was a patent case, actually. He had a case for the Supreme Court. Nixon had a case for the Supreme Court also. Richard Nixon argued was a Time magazine case. A couple of presidents have argued before the Supreme Court. Who else was Nixon? I'm blanking. I know definitely Nixon did and Lincoln did. Maybe there was maybe one or two others. Anyway. So here we have a valid bank, and John Marshall says the power to tax is the power to destroy. Therefore, the federal government cannot be taxed by the state, and the Maryland tax is unconstitutional. Now, but there are limits here, right? Let's say that's a post office. Can the state charge property taxes to a federal post office? The answer is yes, right? Let's say the state has, I don't know, a speed limit. If you have a federal vehicle, does that comply with the state speed limit? Yeah, I think they do, right? So there are sort of limits to this. It's not like absolute, but the idea is you can't sort of regulate it for the purposes of obstructing the federal power. This is a general or neutral tax or a neutral regulation. It's probably okay. This matters, though, a lot with enforcement. So imagine, let's say the federal government says, we're going to enforce slavery laws. And Pennsylvania says, no, you're not. We'll do this case in about a week or so, Prigby, Pennsylvania. The federal law prevails. Pennsylvania cannot obstruct the federal slavery law. Let's do immigration, right? Current events. Feds say, we're going to enforce immigration. They say, no, you're not. States can't interfere with federal power. So this cuts all different ways. Now, the feds can't make the states enforce federal law. That's called the commandeering doctrine. The federal government can't say, you must enforce this. If they want to do it, they have to use their own people. All righty. Questions on McCulloch against Maryland. Again, probably the most important case ever. So we took an entire hour on it. Who said it was long? My friend, this is not a long case. If only God, the Supreme Court wrote opinions like this, we'd be so much easier. Look how big this stupid book is. It's like this, 1,800 pages. Marshall wrote this in longhand while the case was being argued, right, in a couple of days. He wrote this by himself. Give me a break. It's not long. All right, go ahead.
Is the federal preemption like an actual different thing than the supremacy clause, or is it still the same thing?
The supremacy clause provides a basis for preemption. In other words, we have preemption because of the supremacy clause. That make sense? In other words, The reason why we have preemption is because of the Supremacy Clause. Supremacy Clause says the Constitution, the laws of the United States, and the treaties are the supreme law of the land. Anything to the state laws, anything to the contrary in state laws notwithstanding. I think from memory. I think I'm mostly right. Sorry. Yeah, it's Article 6. Just go to Article 6. It's on page 54. Yeah. The Constitution and the laws of the United States and all treaties shall be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. In other words, if there's any state law that's contrary to the federal law prevails. Period. That is the most important part of the Constitution. That one I'm fairly confident. Probably necessary and proper is number 2. It's not that. Look, we could do without the First Amendment. We'd be fine, right? We could do that judicial review. I'm serious. We cannot do without Supremacy Clause and necessary. We just couldn't exist. Now, by contrast, in the Articles of Confederation, Congress only the powers that were expressly granted. And Marshall talks about this, right? In the Articles, only the powers that are expressly granted were given to the Congress. That was an embarrassment. It was called an embarrassment, as John Marshall would say. They only have the powers expressly listed. So implied powers is very important. All right. Questions on McCulloch? Really important case. Anything else? All right. Next case, Gibbons v. Ogden is important. Not the most, probably I would say top 10 of all time. Maybe top 5, top 10, depending on how you want to rank it. All right. Gibbons against Ogden. Who is next? Trent, I think you're next. You want to give me the facts, please, in Gibbons?
So basically, Ogden had like a legal monopoly on like the riverways for trade. And Gibbons was running steamboats up there because he was from a different state.
What states were at issue here? Just so we can get the.
New York and.
Or else, of course, it's New Jersey, right? Everything's legal in New Jersey. That's Hamilton. There's, Aaron Burr and Hamilton, they had a duel in New Jersey, and there's just one line where Hamilton goes, everything's legal in New Jersey. It's not actually true, but dueling was legal at the time. All right, so go on. So we had a problem. New York and New Jersey are opposite sides of the Hudson River. Okay. Who had the monopoly again? Just to make sure I get the name straight.
Ogden has like a monopoly that is like legal from New York.
Who? Just be clear. Which government granted Ogden the monopoly? Was it New York?
The state government.
Which state?
New York.
Not New Jersey.
Yes.
Okay. And then what was Gibbons doing?
Gibbons was running steamboats doing the same thing to New Jersey on the same day.
Right. So ferrying people back and forth between New York and New Jersey. It's a pretty short ride. It's not very far. Evelyn. Yes, I remember. Evelyn, let me ask you this question, please. What was the argument that Gibbons raised of why the monopoly cannot be enforced?
Because he had permission from Congress, it was federal, so it should have been above state.
So what's that word that Rick said it? What's that word that Rick said, that P word? Yes, ma'am. Preempted. Exactly. So Gibbons argued that the federal law regulating traffic between the states preempted any state law monopoly. Under the Supremacy Clause, any federal statute preempts state law. Everyone with me? Now, again, the way things work today is that someone goes to court and says, this state monopoly law is unconstitutional. That's not what happened. Instead, Ogden sought to enforce an injunction, that is to stop this ferrying from going on in violation of the monopoly. Gibbons said, no, you can't do this. So is that Yan? So Yan, in order to decide whether the monopoly is enforceable, what must the Supreme Court decide?
Whether Congress had the power to regulate commerce?
Correct. This is much like McCulloch. In McCulloch, to decide if the tax was valid, you first have to decide, could Congress charter the bank? Here, to decide whether the monopoly was valid, what do you have to decide, Yan?
Whether Congress had the power to regulate commerce?
Between the states, exactly right. So again, it's sort of like these cases arise backwards. Today we think, is a president signs a law, you run to court and you sue to stop it, right? That's not how litigation worked in the 1800s. It arose indirectly, where people sought to enforce state laws, and the question was, did this state law infringe upon some federal law? Everyone understand that point? It's actually, people don't get how these cases actually arise. Oh, no one's. What's with that road? No one's seeing there. It's sort of funny. It's a huge gap. All right, so Laura, I think you're next. All right, so what is the argument that Congress has the power to regulate this? To regulate the movement of boats between New York and New Jersey.
That is navigation, which is encompassed by
Commerce. All right, let's do question number 2. Maybe now is the right time for this. Sure. You hate me with the last question. You hate me more for this one. Short answer. One word. One word. I need one word. Number 2. What does commerce mean? One word. Uno. Don't give me a sentence. No commas. Don't do what people do in the exams, speak the word, they put all the words together. They delete space between words. It's the stupidest thing in the world. They do this every year. It drives me nuts.
Can I ask you a question while they're writing it?
Yes, ma'am.
Why didn't they just root it in admiralty?
I don't know. Why? Why would they?
Because I feel like anything that has to do with the boat, Congress is
Where is that in the Constitution? An absolute power over admiralty. There's jurisdiction over admiralty for sure, but there's no admiralty clause.
But didn't we assume from their jurisdiction that Congress has power over admiralty? Isn't that how they got it?
Is water between two ships considered admiralty? Between two states, or just be in international waters?
I think it can be anything. I think now it's any body of water. This court has said.
Well, that's a modern doctrine. I think at the time admiralty concerned not things between New York and New Jersey. Anyway, okay. Good question though. All right, let's see how people got this right. Okay. Selling. Okay, well, yes, this is correct. This is how intercourse is the correct answer. This is how the Chief Justice defines commerce as intercourse. Now, a couple of you were kind of giggling and snickering. Oh, intercourse, right? Look, it's true, right? It has same meaning as sex. It's true. It's a word. It has multiple meanings, but it's two things coming together, right? Okay, I'm sorry, but that's I have to say because maybe you haven't thought of it that way, but it's true. Ogden, who had the monopoly, argued that commerce meant buying, selling, and trading stuff, right? Buying, selling, and trading. But Gibbons added an additional word, navigation, right? Why is navigation important? Because that would cover boats. So even though these ferries were not buying and selling goods, they weren't carrying goods, they were carrying people. The court ruled that navigation falls within the umbrella of commerce. Okay? Navigation falls within the umbrella of commerce. All right. Oh, Laura, did I ever call on you? Okay, yes. Is it Karen?
Yes.
Karen, let me ask you a question, please. What does among, go to the text here, right? A-M-O-N-G, among. Commerce among the several states. What does among mean? What's intermingled with mean?
Something that is combined with other things.
Good. So just see what Marshall's doing here. He said, okay, so commerce means intercourse, including navigation, and among means mingled with, which again means intercourse, right? Things come together. So what Marshall's basically, again, he was very smart. He sort of saw things out into the future. He's recognizing that commerce does not stop at a state's borders, right? Why? Navigation can go into a state. So imagine a boat starts in New York Harbor and then traveled up a river into New Jersey. You're inside the state. Does Congress lose the power over the boat once it goes inside the state's boundaries? Is the power limited only to the body of water between the two jurisdictions? There's like the admiralty Addie asked about before. The Marshal says, no, that's not how it works. Among can mean commerce which concerns more states than one. Concerns multiple states. So yeah, if a boat starts in New Jersey, it goes up the Hudson River into New York all the way, that's something still Congress can regulate. Now, why is this important? When Congress can regulate something, can the states also regulate that thing? No. When Congress exercises its commerce powers to regulate something, the states cannot. That's why this monopoly is void. Again, let's say that one more time. When Congress chooses to regulate interstate commerce, the states are disabled. There's preemption, Rick, right? There's preemption. They cannot regulate it. So the scope of federal powers is very significant. As the powers of the federal government increase, the powers of the states shrink. Again, when Congress can regulate more stuff in the states themselves can regulate less. It's just sort of like cause and effect, right? When one side gets bigger, the other side gets smaller. Everyone see that point? Brett, let me ask you a follow-up question. It's a trick question, so just warning you. I warned you, I'm fair, right? What happens, Brett, if Congress does not regulate commerce between the states?
Then I guess it opens you up to a wild west on, states doing whatever they like, and there's no regulation between states, no proper guidelines, to like set standards to follow.
If Brett, again, this is a trick question, so I apologize. If Congress does not regulate commerce between the states, can the states regulate it? In other words, can states regulate interstate commerce in the absence of federal regulation?
Within their own state, but not.
I said interstate commerce. Like, for example, could California ban the importation of eggs from chickens that were not treated properly? If Congress hasn't said anything about it. Yeah. Anyone else want to say? Yes. Yeah.
Well, isn't that because there's not a federal thing to preempt it yet? So.
But what if there's like some sort of a dormant, sleeping commerce clause? The idea that even when Congress doesn't regulate something, they could, and the states can't do it. So something called the dormant commerce clause. This is a real thing, I swear to you. Dormant, sleeping, right? It's just not actually in the Constitution. In fact, Justice Thomas thinks it doesn't exist, but it's called the Dormant Commerce Clause. There's a chapter in your book out, I won't assign it. But the Dormant Commerce Clause basically says when there's a regulation of interstate commerce, right, states can't do it. But when there's no regulation of interstate commerce, states maybe can't do it either. I know that makes absolutely no sense. I don't teach it for that reason. It's a very incoherent doctrine, right? When states try to ban stuff coming into their state, it implicates this dormant commerce clause. That's all I'm going to say about it. Just you don't have to know it exists. It doesn't make any sense. Sorry, that's true. There's a chapter in your book. You can read it if you want. I'm not going to assign it. So Brett, I'm sorry for the unfair question. But let's go back to this case, right? So Marshall says that commerce means intercourse and among means intermingled with. And that Congress can regulate commerce in more than one state. This is a very broad conception. Okay? But again, there's a limit, right? What's the limit? Marshall says Congress cannot regulate exclusively internal commerce. That's the phrase. Exclusively internal commerce, that is reserved for the state itself. Exclusively internal. So there's some stuff that's only for the states to regulate. What is that stuff? The chief doesn't tell us. And the Supreme Court really wouldn't tell us any other time. So again, Marshall has this very broad language, right? Oh, here's intercourse, intermingled with more state than one, but exclusive internal you can't do. So he uses this very broad language with this limiting language, and people forget to quote the limits. So in the end, is the federal regulation of this both between the states valid? Yes. So there's a conflict, Ryan, between the federal law and the state law. What happens to the state law, the monopoly law? Preempted, perfect answer. The state law is preempted, and what happens? Monopoly cannot be enforced. Whoever wants, they can ride the rope between the states. All right. But again, Marshall doesn't say commerce means whatever you want to. He puts some limits on it, but those limits are not particularly enforced by the courts. All right. Questions on Gibbons versus Ogden? I don't have a Hamilton video for that one, unfortunately. Watch the entire thing. It's excellent. Watch on Disney Plus. Don't waste your money on the Hobby. You should go to see it for the first time at the Hobby Center. It's good, but it's not the same. Seriously, I took my kids to see Elsa, the Frozen one, and oh god, I let it go. She could not hit the notes. I was so sad. Like it bothers me.
Here?
Yes, here at the Hobby Center. Well, I mean, she was trying hard. I could tell. She practiced a lot. I feel bad, but just she could not hit those notes. Oh, you want to see Wicked? Oh god! So I loved it so much until I figured out they had tune correction. You know what that is? They use tune correction. You know what that is? They basically adjust the voice to hit the higher notes. You can actually put the song into the software. I can tell where the distortions are. I'm so sad. I loved it so much. I'm so disappointed by it. You guys, if you listen carefully, you hear the little scratching sounds, little popping sounds. They actually distort the voice to go higher. Right? It actually breaks my heart. I know you don't care. Things that keep me awake at night. Okay. What else? Anything else on Gibbons? Again, commerce, intercourse, among, intermingled with, more state than one, but not exclusively internal. Good? Good. All right. The next case is my favorite case in the entire book. I mean that sincerely. My favorite case in the entire book, because everything about it's correct. I don't find a single sentence I disagree with. That doesn't happen any other time this semester. It's correct from top to bottom. Marshall nailed this one. He got 100, right? Perfect paper, as they say. So Barron versus the city of Baltimore. And let's start with talking about the Bill of Rights for a minute. Now, we all know the Bill of Rights, What is the Bill of Rights? Well, the Bill of Rights is the first 10 amendments to the Constitution. But it wasn't really called that, at least until the Civil War, and maybe later, depending who you ask. When the Constitution was first drafted in the summer of 1787, there were no special protections for rights. There were a few here and there. For example, you had a jury trial right, and you couldn't suspend habeas corpus and a few other things. But there was no protection of rights. Now, why? Why did the framers of the Constitution not protect rights? There was a fear. What was the fear? The fear was, if we limit certain rights, speech, religion, and so on, it creates an implication. What is the implication? The implication is that there are not other rights protected. Right? If we list 1 through 10, all these rights, people might infer, not imply, people might infer that other rights are not protected. And there was such a fear of this implication that we didn't add a Bill of Rights. After the Constitution was drafted and signed by the framers, it went to be ratified, it was adopted by the states. What does ratification mean? Ratification means that the states, at least 3/4 of them, had to adopt the Constitution. And almost all the states had, almost all the states had conventions. The Constitution was not adopted by the state legislatures, but by a convention of people in the states. And there were debates, they were recorded. Go read Eliot's debates, it's wonderful to read. And many states said, okay, we will approve the Constitution on a condition. That after this Constitution is adopted, that amendments are added to the Constitution to fix things that we don't like. And large states like Virginia, New York, and others put forward proposed amendments. And in the very first Congress in 1789, the ink in the Constitution was barely dry. The first Congress said, okay, we listened to you. We got it, right? I know you people want protecting amendments. We're going to add some amendments. And then James Madison was in the House, drafted, not all of them, but many of what became the first 10 amendments. Now, actually, what's funny is what we know as the First Amendment of free speech, for religion, that was actually the third proposed amendment. The first one concerned redistricting, which never even passed. And the other one concerned congressional pay. That one passed in 1992. Remember the 27th Amendment. But the first one that was actually ratified is one that people know the most about. Again, we could probably do without it, but here it is. And the First Amendment has a lot of stuff in it. You'll take an entire class in the First Amendment. Maybe you'll take it with me, maybe with someone else, I don't know. But it's an entire class on the First Amendment. Okay? Oh, I know this. Whenever I wave my hand, it turns the camera off. That's trippy. Okay, I just figured out what's going on. It's all these hand gestures I don't understand. The First Amendment begins, Congress shall make no law. Congress shall make no law respecting establishment of religion, prohibiting the free exercise thereof, abridging the freedom of speech or of the press, the right of people to assemble or petition the government. Congress shall make no law. Is that Brian? What's the significance of those words? Congress shall make no law. Why is that? Why do I keep repeating that over and over again? Why is that significant?
It's restricted by nature.
What do you mean restricted by nature?
Like it tells the government that it can't do something.
Tells which government?
Congress.
What about the states? What about the states?
Yeah, it doesn't.
Could the states establish religion? They did. They did, in fact. When the Constitution was drafted, many states had official churches. Did you know that? States had official churches. Really, I mean, this is next semester, but this provision really meant, hey, Congress, don't mess with the state churches. Let the states have their own churches. That's what that meant. It wasn't about separation of church and state. It was like keeping Congress have the state churches. That's for next semester. But also, Congress cannot prohibit the free exercise of religion. Right, Brian. Oh, we got Ryan and Brian. It's going to confuse me. Brian, could states violate free speech? Yeah, they could. Could states censor the press? Yeah, they could. Could states impose a uniform religion for all the people? The Constitution, Bill of Rights, did not limit state power. It only limited federal power. The Bill of Rights, the first 10 amendments, did not limit state power, limited federal power. Now, there were limits in the Constitution on the states. That's actually question number 3. Let's see, where's number 3? All right, I'm looking for a number here. Question number 3, go ahead. This section of the Constitution limits the power of the states. Article 1, section blank. Fill in a number, please. Okay, Article 1, section blank. Another 10 seconds. Oh, I love this camera. It's so much better. My tech gets better every year. All right, another 5 seconds. Put in the number. Let's move on. 4, 3, 2, 1. Done. Let's see. Ooh, only half of you got it right. Okay, the answer is 10. Article 1, section 10. There is no Article 1, section 14. I don't know what so is that you? Okay. Don't laugh. If you go to page 39 towards the bottom of the Constitution, this is a section that puts all these limits on the states. And again, think this way. When the states ratified the Constitution, they were agreeing to certain limitations, right? They were agreeing to limitations on their own power. Saying, okay, you know what? We had this Articles of Confederation. It's not working so hot. Congress, we're giving you these powers. We're giving them up. Again, if Congress has a power that probably means the states lack that power. It's a trade-off, and they surrender their power to the central government. But whatever is not surrendered is retained. That's what the 10th Amendment tells us. So what it says, no state can enter a treaty, coin money, right? Pass bills of attainder. States cannot lay imposts or duties. States cannot keep troops, ships of war. States cannot engage in war unless actually invaded. You'll be hearing about this one a lot, right? In other words, so if a state is being invaded, they can engage in war. Yeah. Just you'll be hearing about this one a bit this year. But why is it significant? There are all these limits what states can't do. So, for example, states can't pass a bill of attainder. You know what a bill of attainder is? Do you know what a bill of attainder is?
I think you said it on the first day.
Do you remember?
It's like just a real general warrant where you can look at everything. Maybe not.
You're in the ballpark? Yeah.
Is it like when you get like thrown in jail but no jury trial?
You're really close. Who throws you in jail? You're really close. No, which branch? Is it the judiciary?
I don't think so.
It's the legislature. A bill of attainder is basically a statute convicting you of a crime. Right? The legislature says, we're going to pass a bill saying that, Marilyn over there, she's going to be guilty of a crime. Congratulations. Right? There's no judge, there's no jury. So you both are kind of in the ballpark. A bill of attainder is bad, right? Congress can't pass a law criminalizing a specific person. Now, this actually came up with a TikTok case last, it feels like forever, it was about a week ago, right? In other words, Congress passed a bill that says TikTok, you got to be sold. Applied to basically only TikTok, no one else. Is that considered a bill of attainder? The court said no, it wasn't punitive, so went away. Okay. Also, states can't pass ex post facto laws. What's an ex post facto law? Anyone know what that is? Correct. An ex post facto law is you criminalize something ex post, after facto, the fact. In other words, let's say the speed limit today is 65, and I'm driving 65. I'm good, following the law. And I say, no, effective yesterday, the speed limit's actually 50. And you actually were speeding. That's not fair. I don't know. You can't change the law after the fact. So you can't have a criminal ex post facto law. So what's curious is in Article 1, Section 10, there's a ban on bill of attainders. In ex post facto law, it says no state shall. But there's also Article 1, Section 9. If you jump up to the prior page, it says, it's on page 38, no bill of attainder or ex post facto law shall be passed. By whom? Congress. Article 1, Section 9 concerns the powers of Congress. Again, Article 1, Section 9 concerns limitations on Congress. And Article 1, Section 10 concerns the powers of the states. Article 1, Section 9 concerns limits on federal power. Article 1, Section 10 concerns limits on state power. So in other words, when the framers wanted to restrict state power, they did so expressly. When they wanted to limit federal power, they did so expressly. Everyone with me? So then we get to the case of Barron v. Baltimore. What do we have to do? Alexandra, what were the facts in Barron? The facts here are actually pretty straightforward. What's a wharf? Yeah, it's like a harbor. Okay, people may not know the word, right? Texas is landlocked, kind of. We don't make Galveston. I guess people don't go out there. You want to go to Galveston from there? From Galveston? Oh, it's beautiful out there, people. Yeah. All right, go ahead. It does. Anyway, she said, not me. Go ahead, Alexandra. And what happens when there's a lot of sand deposited in a harbor? What can you not do then? You can't dock your boats. That's correct. Okay, so what happened? Okay, just pause. When you sue someone, you have to rely on a law or something. What did he invoke? Okay, very good. Thank you, Alexandra. All right, so let's just look at the Fifth Amendment for a minute. Where is it? Do I have it up here? Here it is. Okay, Fifth Amendment. It says, and you can see it in your Constitution, so I'm not making it up. It's in there, I promise. On page 66. Oh, actually, it's on 67, the very, very end of it, 67. It says, nor shall private, oh God, this thing is just the right height to hit me. I'm like 1 inch too tall. Nor shall private property be taken for public use without just compensation. I do not see a name tag. What's your name? Okay, just bring it next time, please. If you don't have a name tag, just come to my office. I'll give you one later. Taylor, what does it mean for private property to be taken? What does it mean for private property to be taken? That Liam Neeson movie? What? Was his wharf no longer his?
No.
So
I think he was referencing the usage.
Is that a taking? You thought, right. So you will take property this semester? Next semester. You took property already. Okay. Okay. So you will do something called takings in property, an entire unit. Have you done it already? Oh, you took it already. Okay.
I don't think they always learn.
I don't know what anyone learns. I mean, there's an entire area of property law called takings. When the government seizes your property to build a road, right, to demolish your house to build a road, that's a taking, right? Everyone agrees. What happens when they regulate your property or they diminish the value of your property? It's often claimed that that is also a type of a taking because it diminishes the value. So this case, Barron, is an early example of what you might call a regulatory taking. The idea is that the city messed up the water, deposited all this sand on his land, and he lost his right to use his harbor. He couldn't use it for his profitable purpose. So that's almost secondary. It's not really what this case is about, but you'll learn it later so you remember it. Okay, so nor shall private property be taken for public use. Public use, what does that mean? Use of the public, I guess? Without just compensation, and that's the key. He's like, fine, you want to screw up my harbor? Good on you, but you have to pay me for it, right? You have to pay me for it. You should provide me just compensation. Is that Sharia? Sharia, was there any law under Maryland state law, the Maryland Constitution, that guaranteed compensation for taking property? How do you know that? It's not actually in the case, but how do you know that it's not there? You can draw an inference.
It was implied in law.
How do you know that? How can we be pretty confident Maryland law didn't give Barron a remedy here? What would have, if there was such a law, what would Barron have sued under?
He didn't argue that.
Can you argue that, Juliana?
Because he argued the Fifth Amendment and didn't bring in any Maryland law.
Yeah. If there was an actual Maryland law, he would have used it. I think we all agree on that one. So Barron was like, look, Maryland, you're leaving me hanging, right? There's no law for me to use. So then he turns to the federal law. And Juliana, what does the federal law sort of guarantee, in theory at least?
If they're going to take your private property, I guess that they will compensate you.
Okay. So what did Maryland, Angelica, what did Maryland say in response to this? Actually, the city of Baltimore. I think at the time Roger Taney was a city attorney. I might be wrong on that one, but I think he might have been. He was a future Chief Justice. Angelica, what did the city of Maryland say about this one? I keep saying city of Maryland, the city of Baltimore. My goodness. About the claim, did they think they had to pay damages under the takings clause? Why not? I can't hear you. Did the Fifth Amendment limit federal power? Correct. All right. And so this is basically the conflict in Barron, right? Does the Bill of Rights, does the Constitution's first 10 amendments restrict state power? The court holds the answer is no. Okay. Again, this is a case I think is 100% correct. Everything John Marshall says is correct here. It doesn't always happen. And Marshall makes what we might call a textual argument. He points to Article 1, Section 9 and Article 1, Section 10. He's like, look, in this part of the Constitution, it puts express limits on the federal government. Congress can't do this and Congress can't do that. But here in Section 10, there's separate limits for the states. States can't do this and they can't do that. When the framers wanted to restrict state power, they did so expressly. Okay? Okay. Marilyn, I think you're next. Marilyn, what does Marshall say to, Barron? He's like, look, if you really want a remedy for takings, what should you do? If this is really bothering you and the federal give it to you, what should you do? What can any citizen of a state do if they don't like their laws?
Change it
How do you change it?
in their own state constitution.
Yes, ma'am. Marshall says if this is such a bad situation, go amend your state constitution and put in a right in your state constitution to have a takings clause. Marilyn, what's easier to amend, the federal constitution or the state constitution? Yes. People forget about state constitutions. Everything, federal, whatever. Your state constitution has rights also, and it's a heck of a lot easier. Every time you go vote, right, there's like 20 amendments in the Constitution, which you never read, I'm sure, but they're there. You want to know how hard it is to amend the U.S. Constitution? Go look at Article 5. It's very hard. 2/3 of both houses have to agree. 2/3 of Congress agree on anything? Not usually, right? And then you need to have 3/4 of the states. The 3/4 of the states agree on anything? Not really, right? I try to think of what actually would get a number of states today. I'm not sure. Also, I'm wondering, repeal birthright citizenship, would that actually might clear the hurdle. We'll see what happens in a couple of years. Maybe. So it's hard to actually get amendments passed in the federal system. But it's easier to pass an amendment under state law. Marshall also makes a historical claim, right? One of the fears during ratification was that you had this powerful central government. And you had the anti-federalists. Who are the anti-federalists? They opposed ratification of the Constitution. And the anti-federalists were worried that this new central government would swallow up the states. We give this federal government all this power. Do you think it would have come as a surprise if the anti-federalists were actually restricting their powers, that they couldn't pass laws about property and speech and so on? No. There was no intention to apply these restrictions on the states. Can I tell you another reason why? Slavery, right? Fifth Amendment. A person cannot be deprived of life, liberty, or property without due process of law. If you applied that to the states, slaves could raise claims that they're being deprived of their liberty. It wasn't said here, but that was sort of understanding that you could not apply it. It was only the federal government that could have these restrictions. Marshall's view became the settled understanding of how and why the first 8 amendments did not restrict the states. This would not change until the Civil War. And the ratification of the 14th Amendment created what's called the incorporation doctrine. Incorporation, what does that mean? The incorporation doctrine says that the provisions of the Bill of Rights now limit the states. This didn't happen all at once with one fell swoop. It sort of happened gradually over time. And today, almost every aspect of the Bill of Rights now limits the states. There are a few exceptions. For example, there's no right to a jury trial under state law in a civil case. There's no civil jury right. And it's not clear that the Third Amendment of quartering troops has been incorporated either, but that doesn't have too much impact on our day-to-day lives. But that is the incorporation doctrine. All right. Questions on Barron? Yes, sir, Michael.
So I guess my question is they write this opinion to just talk about how they can't do anything about this? Like
Who's they?
The Supreme Court. Maybe I'm not understanding why they, if they were saying that the Bill of Rights had no application of what the state would do,
right?
Why were they giving an opinion on this?
Well, that was the basis to reject Barron's claim.
Okay.
Right. In other words, Barron sought compensation under the federal Constitution, and the court said, "Sorry, Mr. Barron, you lose because the federal Constitution The federal constitution does not limit Baltimore.
Mhm.
Therefore, your claim fails.
Okay. Yeah, yeah, that makes sense.
If you notice, all of these cases arose from state court proceedings, right? McCulloch was from the Maryland courts with imposing the tax. Gibbons arose from a monopoly in New York State court. And this one arose from a Maryland state court, again, trying to impose this, trying to seek damages against the government. There's another issue. Can you sue the state for damages? The usual answer is no, you cannot, unless the state consents. Maryland had not consented to a suit, right, because of sovereign immunity. That is, the sovereign is king. So again, Barron was trying to work around saying, look, the federal constitution says I can sue you. Congress can get rid of a state's immunity in many cases. But the court says, no, this constitutional provision says nothing at all about the states. Again, correct decision. Marshall got it right here. I can quibble with the other ones a little bit, but this one he got right. Questions on Barron? Yeah, Ted.
Just for clarification purposes, the incorporation doctrine and the 14th Amendment, they're kind of laid together. They're talking about the same concept in your either or.
Right. Incorporation happens because of the 14th Amendment, right? Incorporation happens because of the 14th Amendment. Right? The reason why we have the incorporation is because of the 14th Amendment. The specific part of the 14th Amendment, the courts haven't always agreed upon, but because of the 14th Amendment, the Bill of Rights now limits state power. Okay. Questions on Barron? Questions on Barron? Okay, so let me try to sort of synthesize these three cases together. What these three cases, McCulloch, Gibbons, and Barron represent is sort of a strengthening of the central power of the federal government, right? McCulloch said that, yes, Congress has these implied powers to establish a bank. We're not limited to that which is enumerated. There are certain implied powers. And Gibbons likewise said Congress has broad powers not just over buying and selling stuff, but also intercourse and navigation. But there are limits. One second. But there are limits. The Bill of Rights and the first 10 amendments do not limit state powers. The states retain their sort of sovereignty in many spheres, unless it interferes with something that Congress expressly reserved for itself. Yes, Taylor, was it?
Yes. You said not just buying and selling, but what? I didn't hear you.
Navigation and intercourse. Okay. Questions? All right. I don't have anything else. I'll just ask just one more favor. I try when I close class, I forgot to do it last week. I do kind of an exit polling. You have no obligation to actually write anything. If you have any sort of questions or comments, I read these after class. Just type something. If you have nothing to write, you don't have to write anything, it's fine. But this is just a way for me to see what's working, what's not, and what might make sense, what doesn't make sense. Just my way of sanity check. So just, it's open. All right, that's all I have. Thank you all so much. I'll see you in class on Wednesday.
We don't have a professor that teaches admiralty law, do we?
I don't think so.
That's what my brief is on. That's why I'm thinking about it.